Objective truth is that there is no objective truth.
Like, you kill a baby fetus, the same thing as killing any old inanimate object.
I would argue that we certainly are not all created equal.
Mark is training a new generation of leaders.
To take on the culture of death and win.
You young people, it's your movement now. It's not your parents anymore.
The blood that is shed cries out to God from the ground for justice.
And now, here's Mark.
Judicial activism, legislating from the bench, judicial supremacy. That's what we're going to be talking about today on the Mark Harrington Show with your radio activist, Mark Harrington. And you can find out more about our radio program by going to markharrington.org. And you can find out more about Created Equal, the organization that I head up, by going to createdequal.org. Well, folks, I mean, 2020 has been, to say the least, a very different year for many of us, of course. With the COVID-19 crisis, then we have the riots, the looting, the arsons, the protests, and now the U.S. Supreme Court's starting to hand down their decisions, and that generally happens around this time of year. That is June each year. They hand down their decisions, and this week, on Monday, the United States Supreme Court handed down the decision in Bostock versus Clayton County, Georgia, in a 6-3 decision. They basically wrote that the Title VII, that is the 1964 Civil Rights Act, includes sexual orientation and gender identity as reasons you cannot discriminate in employment. And so we're going to be talking about that today and the implications of these types of decisions. The majority decision or opinion was written by Neil Gorsuch. And of course, Gorsuch is one of Trump's recent nominees, appointees to the U.S. Supreme Court. We thought he was a textualist. We thought he was a strict constructionist. You got to wonder after this decision where he stands. And of course, unfortunately, Justice Roberts joined him in the decision. In order to talk about this, we're going to be talking with my good friend and colleague, that's Catherine Short from the Life Legal Defense Foundation. Catherine, thanks for being on the program.
Thanks for having me, Mark.
So, we're looking at the U.S. Supreme Court, those who watch it very closely, and I know you do. And this decision that was handed down on Monday, along with the decision that I guess forbade churches in California from opening up just several weeks ago. We're seeing recent decisions that continue to indicate that the U.S. Supreme Court is unlikely to stop this trend that's been happening now for a generation of legislating from the bench. That means basically making law rather than leaving it to the U.S. Congress or the state legislatures to make. They're usurping the separation of powers. Basically, we have one branch of government that basically is more powerful than the others. That's judicial supremacy. This decision on Monday, this decision, Bostock versus Clayton County, Georgia, how do you read it, and why do you think it's a problem as we look forward, as pro-lifers, we look forward to the June medical decision that could be coming out in days, and then, of course, ultimately, Roe versus Wade?
Mark, the funny thing that happened in that Bostock decision was that Gorsuch, if you asked him about it, you might say he was doubling down on textualism. He was doubling down on saying, he said, as was described by the dissenters, is he was looking at the literal meaning of the words instead of the ordinary meaning of the words being on the basis of sex. When that law was passed, what people would ordinarily think that means when you talk about discrimination on the basis of sex means discriminating between men and women. Right. And certainly at the time, that was the understanding. And Gorsuch doesn't even really dispute that. But he took such a granular, finely defined version of what it means to discriminate on the basis of sex that it meant if you would not treat a man and a woman in any respect the same way, then it was discrimination on the basis of sex. So, and it kind of depended on what was the rest, what was the predicate for that? Well, he would say, well, if you would allow a woman to be in an intimate relationship with a man, then you got to allow a man to be in an intimate relationship with a man. You can't discriminate on that basis. Whereas the more ordinary reading would be neither we would not hire either men or women who were in intimate relationships with persons of the same sex. That would be the ordinary meaning of it. In other words, we are treating men and women the same, whereas his, you might say, ultra fine definition of on the basis of sex meant that if there's any way you could fill in a sentence that you wouldn't say man and woman the same way, then it was a discrimination on the basis of sex.
My guest is Katie Short. She's with Life Legal Defense Foundation. You can find them at lifelegalDefenseFoundation.org. Katie, what I find very troubling in this decision is apparently the United States Congress was actually for years now trying to upgrade the Title VII law to include sexual orientation and gender identity. Why do you think the U.S. Supreme Court would jump in the middle of this? Why don't they allow the legislative process to handle it? I mean, why are we seeing this continuing over and over again, where they jump in where they don't belong?
It is a mystery to me as well, Mark. I don't understand that, and it wasn't like nobody pointed that out. That was the subject of a lot of the principal briefs, the amicus briefs, the dissent. They went through that entire history of the attempts and getting closer and closer to writing those gender identity and sexual orientation into the statute. Had never quite done it, and as was pointed out, because the court did not wait for the Congress to do that, instead jumped in and leading the parade, apparently what they thought they were doing. There is no room then for distinctions and exceptions that would happen through the legislative process. Like, do we want to make an exception for sports,
right?
Locker rooms, bathrooms, the things that we're seeing happening at the state level, where those things are being argued about, and the process is gone through in an orderly, somewhat way, but at least there is a discussion of those things. In this case, as with Roe versus Wade, the court steps in, paints with a broad brush, and then there's no more room for that sort of negotiation and bargaining and discussion of whether this makes sense in all these contexts.
I also understand that actually in the opinion, Gorsuch mentions that there are these issues are out there and are going to likely come before them in the future. And there's already some in the pipeline regarding sports and bathrooms and all of that. I just don't get it. Here's one of Trump's nominees, right? I mean, he went through the process. He considered himself a strict constructionist. One reason why we vote for pro-life or Republican presidents, generally speaking, is because we want those types of people on the U.S. Supreme Court. And then half of them, generally, I mean, if you look over the last 40 years or so, half of them disappoint us and head in the other direction. We're seeing that with John Roberts, the Chief Justice. So it puts into question this entire strategy that we have followed for a long time as pro-lifers, and that is to change the law, the Roe v. Wade decision, to strike it down, to overturn it. We want to elect presidents who are pro-life or strict constructionists or believe in that, and then put those types of people on the court. But inevitably, they disappoint us, and that's what's happening here. I wonder, what do you think about the entire strategy? Should we throw it out now, or we continue to work to try to keep those types of people in the White House and put those kind of people on the court?
Well, I certainly wouldn't throw it out until someone comes up with a better alternative.
Better plan, yeah.
So,
which I want to talk to, but maybe there's other alternatives. But yeah,
and we also see, in the lower courts, There are changes. It's always better to go up to the court as the as the appellee than the appellant, and so there are still changes happening in the courts, the lower courts that we are seeing the effect of, just not so prominently as you see in the Supreme Court has to have a decision like this.
Well, clearly, Justice Gorsuch is a disappointment. I'm hoping this is an aberration because we have this upcoming case, June Medical versus Russo, dealing with abortion, dealing with the hospital privileges that are required in the state, I think it was Louisiana, right? Where those are required of abortionists in order to be able to, keep these places open. You were sitting in the courtroom that day. This was in March. I was outside in front of the U.S. Supreme Court on that day. I think it was March 4th or something like that. In 2020, when they heard the case. I know I don't want to ask you too much here as far as looking into your crystal ball, but you were in the courtroom, you heard the arguments. How do you think the court's going to land on June Medical, which is another key abortion case?
Well, I think don't get your hopes up.
Okay.
That's what I would say. But that's the bad news. Bad news is don't get your hopes up. The good news is as this case played out, we also filed some amicus briefs, which brought me to some familiarity with the issues. As this case played out, its role in the overall abortion legal battle strategy of the Supreme Court, to me, seemed to get kind of smaller and smaller. And you could never see that ahead of time. You can only see as these things, as the arguments are made and as they are played out. And what I saw was the issues becoming more and more fact intensive and locked into the facts of what was going on in the ground in Louisiana. And even more specifically, what was going on with doctors, Doe 1, Doe 2, Doe 3 through 6. They were down at the level of saying, now how hard did Doe number 2 try to get admitting privileges, and which hospitals did he apply to, and how long did it take to get the response? And it was extremely fact intensive. And so I will look into my crystal ball on this one, and I am afraid that I think we're going to lose. And I think
you think it'll be a 5-4? You think Roberts will be the swing on that one?
I think he will be the swing. I will say, I'm going to guess he will write the opinion. And in a way, I would say, I hope he writes, if that's the way it's going to go, I hope he writes the opinion and writes a very narrow opinion that says, well, this statute didn't make it. We're not saying that no admitting privilege statute could be upheld. We're not saying that clinics will always have standing to bring these actions. What we are saying is that in this case, this standing, the way this litigation went, you didn't make it.
My guest is Katie Short, VP of Legal Affairs with Life Legal Defense Foundation. We're talking about the U.S. Supreme Court and the decision this week on Monday to extend Title VII protections to sexual orientation and gender identity, and the implications of Neil Gorsuch now siding with the quote-unquote liberals, if you want to say, on the U.S. Supreme Court, and the implications on that as far as June Medical and Roe versus Wade. So in June Medical, I don't want to get into the weeds here too much, Katie, but in several years ago, after the death of Samuel Alito, the court had a similar case, and it came out 4-4. It was a split, and so the lower decision stayed in place. Isn't this a similar decision? And does it really affect abortion, I guess, overall? Is it going to be a big landmark kind of a decision, or do you see it as not being that critical to our, going forward in our fight to protect unborn children?
Just a few corrections. It was not Samuel Alito. It was Justice Scalia.
I'm sorry. It's Scalia. I'm sorry. You're right. Thank God Alito's still on the court.
Yes. But I also, if you're talking about the Whole Woman's Health versus Hellerstedt case,
Yes.
that was actually 5-3. So we
5-3.
weren't even with Scalia on the court. We would have lost that one because it was Kennedy in that case who sided with the liberals.
Okay, I'm sorry.
And that is the problem. That case set that is the precedent to meet in this.
Okay.
In the June medical services. And that is exactly the point that was hammered by the attorney for the clinic in Louisiana, and she pitched it exactly to Chief Justice Roberts' institutional concerns about the court, the idea that no, we're not going to overturn precedents just because now we have the numbers to do that. That was kind of you could tell that's what she was pitching it to, Whole Woman's Health, that's the precedent now. And there's no good reason to depart from that. And at the argument, he kept pressing on that, and it was almost like, give me a reason to overturn it. Give me a reason to find that this is different from Whole Woman's Health. And it's not clear that the Solicitor General succeeded in doing that. One of the questions had to do with, does this admitting privileges law, you had to have admitting privileges within 30 miles of where the abortion would take place, and the argument on the other side was that just doesn't make sense. If it's to prove that the doctor can get credentials at the hospital, why does it have to be within 30 miles? If it's for the whole continuity of care issue, they admitted that a lot of women, they only have their complications when they go home, especially when you're talking about the abortion pill. So to say, why do you have to have admitting privileges within 30 miles of where the abortion is done, or within 30 miles of the clinic? And there were not really, good responses to that. But again, that's where I could see Roberts saying, I'm not saying that all admitting privileges laws are bad. I'm just saying, maybe this 30-mile limit doesn't really work, or
right.
Only for surgical and not for medical abortions, things like that.
Right. Well, I was outside the court for that in March, and I've been at this for many years, Katie, and so have you. And it's frustrating as you're sitting outside the court thinking about what they're deliberating inside, and we're not talking about whether abortion is constitutional or not, whether Roe v. Wade should be overturned after 46 years. It's very frustrating as a pro-life activist to think that we're still kind of trimming around the edges here after 46 years. And I just want to ask you, if you look at the court right now, obviously we have two conservative, strict constructionists. I think they're bona fide textualists. That's, Justice Thomas and Alito. The others, we don't know. Kavanaugh, now Gorsuch, you don't know. And I think Roberts is a problematic. There's a lot of talk about the imminent overturning of Roe versus Wade if Donald Trump were to get reelected. How do you see it? I don't see it in the math, and I'm not trying to be, Johnny Raincloud here or anything, but I'm a realist, and I look at it and I think we don't have the numbers, and if he gets reelected, that's a good thing, but that still doesn't guarantee this. So how do you see it going forward?
I think one of the things that was disturbing to me about the June Medical Services case is that the way, and I certainly agree with you about the, nibbling around the edges, is that the pro-lifers, the quote unquote pro-life position on this had to be, for the way the issues were framed, was, don't worry, women will still be able to get abortions.
Right, which was frustrating. I was out front, and that was the talking points of the pro-lifers, and that would just drive me crazy. Yeah, and it was. Sorry.
Yeah, we're just trying to make abortion safe, and I admit, Mark, I was like, I'm with the the anti-abortion movement, not the pro-safe abortion movement.
No, right.
And and I realized things happen during litigation, and you make your best strategic judgments about how to argue a case. Yeah. But I was disturbed by that, the fact that it was, the pro-abort side was, this is going to cause clinics to close. The pro-life side was, no, it's not. or you haven't really proved that it's going to cause clinics to close.
Right.
And that, to me, I left there looking forward to. I went back, in fact, searched a lot of docs to see, okay, when is a case coming up that will actually really confront Roe versus Wade, really confront Planned Parenthood versus Casey, say, what a heartbeat bill,
what are those? I mean, because people are interested in that. They think that the court could basically reverse Roe on any abortion case. Is that the truth, or is it has to be something that deals with the legality of abortion directly, like a heartbeat bill or a total ban on abortion?
I think it's going to have to be something that is irreconcilable with Roe, because
Gotcha.
that was these cases, Hellerstedt,
Right.
medical services, they have been argued on the basis that these laws are reconcilable with Roe. And, and so it's always like, don't worry, you can uphold the law without overturning Roe.
Yeah. So
And
speak to that in the time that we have. I want you to speak to the as you look ahead, you look at the court, you understand the court. Where do we stand? Let's assume that Trump gets reelected. Best case scenario.
Well, I think it's generally agreed. I think now the thinking is, not to speak for this whole amorphous pro-life legal community, but that Roberts is not going to be the one to take the court to overturn Roe on a case where they're not explicitly asked to overturn Roe, or that is not the only choice to overturn Roe. And then, therefore, I think a case like that has to come before them. And I mean, I'm not ruling out that Roberts, along with the other, Gorsuch, Alito, Thomas, Kavanaugh, could vote to overturn Roe versus Wade, even without another justice there. But I think it's going to have to be done on a case that directly contradicts Roe. And with a great factual record to back it up, I think is the other thing.
And do you think it's going to have to be more than a 5-4? I mean, a lot of people believe it has to be a super majority, more or less, a 7-2, 6-3, because that's what Roe was. Roe was 7-2.
Right. Well, legally, it doesn't have to be. Legally, it doesn't have to be. If you're.
But I mean, because Roberts is more of a consensus builder type Chief Justice.
And in that case, he's never going to get that consensus from, obviously, any of the liberals currently on the court.
No.
So, yeah, you would definitely have to have one of them retire and be replaced. And a lot of the talk says best, would be really good if it was a woman.
Right.
And
well, I've been sending retirement brochures to Ruth Bader Ginsburg for decades, but apparently she's not reading them.
I was sitting in the court in about the same time in 2014 and looking at her and thinking, wow, she can't last much longer. So,
I don't know. I think she's going to hold out.
Right. So,
we got about a minute left, Katie. Let's wrap this up. I understand that it's going to be disappointing for pro-life activists, and we need to continue to work. In my view, we need to work for the re-election of Donald Trump, obviously, because we can change the court and hopefully bring about the overturning of Roe versus Wade. But I think we're at the point, and I've been advocating this for years, is that we just stand up to Roe and we find out if we can find a state legislature who will pass a law to ban abortion and then have a governor and an attorney general enforce it and see what happens. Nullify Roe, defy it. What do you think of that in the few seconds we have left? And I know I'm not going to give you enough time to give your opinion on that. But there is, some more people out there starting to think, going this direction ain't going to work. We got about 30 seconds.
Well, I think it would all depend on how that was brought about. Whether you're talking about straight executive action, we're going to padlock a clinic, whether you're talking passing a law that, and then it takes the federal marshals to come and unpadlock it, or whether you are talking about prosecuting an abortionist, in which case you're going to have to get the third branch of state government involved and get the judges in the state
law enforcement,
come alongside on that, because they may say, well, we can't, the state's brought the defense motion is that this contradicts Roe versus Wade. What am I supposed to do?
Yeah, so we're going to have to go. Katie, thanks for being on the program. Again, Katie Short from Life Legal Defense Foundation. You can find out more by going to Life Legal Defense foundation.org. We'll see you next time. God bless you. God bless America. And remember, America, to bless God.
You've been listening to Mark Harrington, your radio activist. For more information on how to become a witness against the evil plague in America, call Created Equal at 614-269-7808. That's 614-269-7808. Or go online to createdequal.net. Createdequal.net. Be sure to tune to the Mark Harrington Show next time for your marching orders in the culture war.